Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, as the title suggests, we'll be discussing the I-864W form, again briefly and within a limited context. What is the I-864W? It's actually a rather interesting form. I have used it primarily in the context of Child Citizenship Act cases. Those are cases in which there's an American citizen parent of a child born outside the United States, or, well, no, it couldn't be born inside the United States, but child born outside the United States to an American citizen parent, and that parent could not automatically transmit United States citizenship at the time of the child's birth. For more information specifically on the Child Citizenship Act and the ramifications thereof, I suggest checking out the videos specific to the Child Citizenship Act on this channel. But that being said, moving forward, there are scenarios where an American citizen can sire or give birth to a child abroad and not be able to automatically transmit their United States citizenship at the time of birth. This is based on relevant statutory law with respect to this issue. A requisite amount of physical presence in the United States needs to be met in order to automatically transmit birthright citizenship to a U.S. citizen child born abroad. In those instances where that does not occur, it is possible for the American citizen to file an immigrant visa petition on behalf of the underlying child and go ahead and process that immigrant visa petition through the relevant organs of the Department of Homeland Security, and then go ahead and consular process the visa petition at a U.S. embassy or U.S. consulate abroad. Under those circumstances, under normal circumstances when processing an immigrant visa, you're going to need to use forms such as the I-864, the I-864A. For more information on both of those forms, I suggest checking out their respective videos on this channel. But going back to the I-864W, in the instances involving American citizen parents with non-transmitted non-U.S. citizen children, and this is specifically within the context, or I guess, yes, it would specifically be in the context of minor children, the I-864W is going to be necessary. What is it? Well, the I-864W is an interesting form because, in general, the I-864 creates it creates a financial obligation on the signer with respect to various merit-based, or I should say needs-based benefits in the United States. So if the signer of an I-864 brings an American citizen spouse over to the United States, and let's say they get divorced, and then that immigrant spouse goes on to aid to families with dependent children, or some other need-based, for lack of a better term, welfare initiative in the United States. Under those circumstances, the person who signed the I-864 is liable back to the U.S. government for reimbursement of the capital spent on the individual who is utilizing those benefits. So, and there is some case law on this topic specific to this issue. The interesting thing about Child Citizenship Act cases is children who are born to U.S. citizens abroad but do not obtain their citizenship automatically at birth. That American citizen can petition for an immigrant visa for that child. That child can travel with that American citizen into the United States in order to take up residence in the United States. And this is key. Upon admission to the United States of America by U.S. Customs and Border Protection, as long as that child's a minor, is coming in an immigrant status, and has a U.S. citizen parent who's a U.S. citizen parent, upon entering the United States, that child becomes what's called a United States citizen by operation of law. So they become a U.S. citizen. It's sort of almost like a plenary indulgence with respect to the Catholic Church. By passing through Customs and Border Protection and being lawfully admitted, that individual just becomes a U.S. citizen at that moment. So the interesting thing is, upon becoming a United States citizen in sort of a more routine context, let's go back to the I-864, if that immigrant spouse was to naturalize to U.S. citizenship, the I-864's obligations are extinguished, and that now U.S. citizen can go on means-tested benefits in the United States in and of themselves. They're a United States citizen. So the I-864 obligations no longer apply. It's extinguished against that American citizen joint sponsor from the previous immigrant visa application. Because the child traveling through Customs and Border Protection becomes a United States citizen by operation of law automatically at entry, this whole issue of reimbursement to the government is kind of a moot point. So essentially, the immigration apparatus came up with the form I-864W, which is effectively a truncated I-864, I guess in theory, for that brief window in time between coming off the plane and being admitted through immigration, where that person is sort of in limbo. But upon being admitted to the United States, so long as that child remains a minor, accompanied by their U.S. citizen parent in immigrant status, they become a U.S. citizen by operation of law. These 864 obligations are extinguished, and it's all sort of a moot point. So it's the reason why there's a specific form, the I-864W, exactly for these sets of circumstances.